Mm, Okay, so hello everyone. Welcome to the last session of the Federman Cyber Workshop for this academic year. We have with us Dr. Asaf Lubin to discuss his new article, Selling Surveillance or Buying. It could have been also Buying Surveillance. Uh, we are always delighted to hear from Asaf, which joins us from Indiana University, Maurer Law School. You all know Asaf and his numerous activities, publishing two new books only this upcoming year, working alongside his teaching responsibilities, also as an associate and a fellow at the Berkman Klein Center for Internet and Society at Harvard University, and also at Yale's Law School's Information Society project in more activities. And of course, is gracious enough to also dedicate some time to the Federman Cybersecurity Center. So thank you for that, Asaf. We look forward to hear your presentation and to discuss it.
Awesome. Well, I'm really excited to be here. It's been a while since I presented here, and I always enjoy this presentation. Also because I'll be at Columbia Law School in the fall teaching a seminar with Professor Matthew Waxman, who also presented at Fetterman not so long ago, on espionage. And in particular, we're devoting a session on commercial spyware. And my work on this has been in part influenced a lot by conversations I've had with Matt on some of these issues, which I hope to get into. But it's also exciting because I'm coming full circle. So this entire research started with an email from Tal about 2 years ago, where Tal reached out and said, we just visited NSO Group in their offices. They're now looking to reach out to American academics. Can you lend a hand? And I'll be honest, I was a little unsure about whether I wanted to lend a hand. And the more I landed the hand, the more there was some criticism from people here in the American Academy about me landing that hand. But that led into all of this, and I couldn't be more happy with the final outcome. The last thing I'll say as an introductory note is that this is subject to a revise and resubmit with the American Journal of International Law, and I will hear within a week whether it got accepted. So the number one thing you can do for me today is just to send good feelings over that it get accepted for publication. But that is it. So let's talk about commercial cyber and its commercial spyware and its regulation. I'm going to share my screen. I will say at the outset that this is very much a work in progress. Beyond this particular paper, I think that we're going to see a lot more discourse around more sophisticated answers on how to redesign governance schemes for commercial spyware. And there's no better audience to talk about this than what is going on in Israel right now, including just yesterday with the statements from the chief of police about their need for reintroducing commercial spyware into their business of law enforcement activities. And so thinking through how to best utilize hacking tools for investigations, I think is something that will carry through a lot of the work we do in the years to come. Okay, so the core argument of the paper is that we've been looking at the regulation of commercial spyware wrong. And it's rooted in this embrace of something that NSO Group said in that, so they gave a 2-hour presentation to 25 American law professors. This was about a year and a half ago. And their number one claim was this: we are a technology company. We are nothing more than a technology company, and you can regulate us if you want to regulate us as a technology company. And when you say something like that, what it entails is a set of pre-existing notions and tools that you have at your disposal in the regulation of technology companies: export controls, human rights tools, and corporate governance tools, and certain ad hoc civil and criminal litigation tools. And we've seen them being utilized in other contexts, and a company like NSO Group would just say, use those tools against us too, when necessary. So where necessary, use export controls to regulate through licensing what of our tools can or cannot be sold and to which countries and under what circumstances. Where there is a violation of human rights, impose the same human rights standards you always impose. In the same way, for example, the content moderation should be governed by Google and Meta and Apple. So use the human rights frameworks, that is self-regulation by the companies, and where necessary, some government regulation of the obligations to protect human rights imposed on the companies located within their jurisdiction. And finally, where there is a bad apple, impose civil and criminal liability. All of these tools, when tried against commercial spyware, don't work. And when they all fail, we revert back to the final option, which is a ban. Just sanction and ban and blacklist either particular companies or the entire market. And what I argue in this paper is that at the first half of this paper is that none of these tools have worked. I think that part of the paper is not particularly innovative. I think that most of you will already know, or at least will have intuition, why none of these tools work. So I'm going to limit this part of my presentation, but I will still describe the core arguments of it, because I really want to focus our discussion. What I think is the hardest part is where do we go from here as an alternative theory. But let me just go one by one and just show you why they don't work. Export controls offer some benefit, and the biggest one is that they offer an international arrangement that is already available to us, and that international arrangement comes with the ability to meet in a forum in Vienna to discuss issues and come towards collective implementation. And there's no question that the only way to address this problem, because of the scalability issues associated with it, because of the fact that these companies can rebrand and remarket and operate. So that's that last bullet there about the weakest link problem. These companies will just gravitate towards the country in which there is the most lax regulation and the most lax export controls regimes. And so we have to have an international framework, because otherwise there's always going to be a loophole through which these companies can continue to operate. But there are pitfalls with this arrangement as it's currently designed. That is because this is a non-binding agreement, the Wassenaar arrangement. It lacks enforcement mechanisms. A number of key players, including Israel, that has committed itself to Wassenaar, are still not parties to Wassenaar as such. China, Cyprus, and the UAE are just other examples relevant in the spyware space. And it does not prohibit the purchase of a surveillance technology from a non-participating state. So even if you are a party to Wassenaar, you can buy from a non-party to Wassenaar, and that non-party is the party that controls the export controls, and therefore it doesn't create the oomph that it could on regulating the market. But there's one point that Tal wrote, and I cite to in the paper, that I think is brilliant, and I'll be honest, I didn't think of it until Tal wrote it, which is the export controls are very much a post-development measure. And the problem is that by the time you impose the export control, it's already too late, because you've already sunk so much cost into the development of the tool that it's going to be really difficult to go back and redesign the tool. And there's going to be an incentive structure to not impose too burdensome of an export control regime on a company in your territory. And so we're left with technologies that might already be non-privacy by design and non-security by design left in the market, even if with a license regime. So those are the problems of the export control regime. As for the human rights framework, one could think that human rights might do a good job in regulating some of these behavior, but to understand the problem is to understand every problem in business and human rights law. We need to look at all the triangular actors in the game. So I'm going to go in order, starting with the spying state. The problem, obviously, is that many of these spying states are by themselves human rights violators who have no incentive structures, and there's the broader under-enforcement problems of human rights law against these kinds of actors. Some of them are non-parties to relevant treaties, and when we try to impose on them customary norms around human rights law, there's ambiguity about the scope of the customary obligation vis-a-vis the treaty-based obligation. And this is especially true in the context of spyware, where much of the work has been done. Yuval knows this very well. Much of the work has been done through treaty bodies and courts who have in the last decade developed a framework for human rights in this space. But that framework is so tied to the treaties that they are interpreting, and where we try to apply customary international law, there is a question of whether or not whatever the Human Rights Committee has said about the right to privacy is part of that custom, as opposed to whether it's just binding vis-a-vis the ICCPR specifically. But more importantly, I think that the real problem is that we do not have today an agreed upon human rights framework tailored for the unique features of lawful hacking. And I think that there are particularities related to spyware that will need to be further massaged around the general framework of legality, necessity, proportionality, adequate safeguards, ex-ante export review, transparency and access to remedy, all the things that we know by heart by now. But how do we apply them to the unique harms that are produced by spyware and the unique challenges for regulation that are imposed by spyware? I think that requires particular tailoring that is currently missing. And there's obviously the problem of derogations in times of emergency. Okay, so that is all for the spying state. Moving now to the spyware companies, surely we can rely on the UNGPs. And in fact, I'll just mention, I'll skip just to this slide. The US Department of State put what I think is the most robust guidance or framework for human rights obligations of surveillance technology companies. It is a pretty robust, non-binding recommendation for these businesses on how to implement the UNGPs in the surveillance context. I think it does apropos that desire for tailoring, I think it does a pretty good job of making certain suggestions around human rights impact assessments, around human rights by design, on the need for contractual language to constrain clients in this space, around transparency obligations. But as is true for all the UNGPs, they lack any formal and institutional structure to ensure compliance with these kinds of commitments and to ensure accountability whenever these commitments are violated. All of the enforcement of the UNGPs is dependent upon domestic regulation by the states, and where such domestic regulation is lacking, the result is that the companies should be trusted to self-regulate, and the companies themselves lack sufficient incentive for self-regulation, and they particularly lack sufficient incentive for self-regulation because there's not going to be consumer action. So there's not going to be the kind of tools that we usually rely on for markets to self-regulate themselves, because this is a national security environment where much of this is secret. By the time we learn we were hacked, that there was a breach, it might be too late to take an action. There might be standing issues for bringing in actions because of the cross-jurisdictional nature of these activities. And the result is that trusting the companies to not take the benefit of making profit as opposed to working towards human rights protection, it's just really hard to assume that that will happen. And that is, of course, not new to the literature. We see it in other contexts of human rights abuses or environmental abuses by companies. I think it's just more dramatic in the context of an already problematic national security environment. The last set of problems obviously relate to the exporting state or the licensing state. And I've already talked about the exporting control problems of these kind of countries, but there's even more problems on imposing human rights obligations on them. One has to do with the incentive structure. So these countries, as we saw from Israel, have a surveillance diplomacy interest here. They are making profit too, not just the money that is coming in from these companies, but they're making diplomatic profits from having a robust surveillance industry. And more importantly, for some, the availability of a dynamic cyber corporate environment ensures stronger cyber capacities for the state. And so not wanting to restrict their activity too much out of a worry that they will leave the country, operate somewhere else, entails a worry for them that they will not have the necessary vibrant cyber corporate ecosystem that they need for the future cyber warfare of tomorrow. So that's on the incentive structure. As for proper law, human rights law has a lot of problems with holding these kinds of countries liable. So I talk a little bit about license and complicity regimes, both complicity under Article 16 of the ILC Articles on State Responsibility, but also complicity as a human rights standard, and their requirement for some knowledge that goes beyond mere negligence in order to hold the country liable. And then license and due diligence law, which imposes a lot of hard questions around whether there is a do no harm principle in cyberspace that's been talked about ad infinitum and to death, I think by now, as well as the extraterritorial application of human rights due diligence obligations. So the obligation to protect and to prevent under human rights law, do they extend extraterritorially, especially in a situation like this, where the country is no effective control over the use of the tools? It's merely licensing the companies to sell tools to third countries. It is now too far removed along the causality chain for us to be able to manifestly say that it had effective control over the activity in question. This is just to show why human rights law, I think, is insufficient in and of itself to solve this problem. So that leaves us with ad hoc civil and criminal enforcement. And we've seen a lot of that against NSO Group as one particular case study in the last year and a half, both in the context of civil action by companies like Facebook, Meta, and Apple, as well as by the US federal government taking action to blacklist and sanction NSO Group. And there are some benefits here, because I think more than anything, this hurts the company's liquidity, and it also hurts the company's ability to access necessary infrastructure. So in the wake of these blacklisting, Amazon denied NSO Group the ability to access cloud services that it needed to run its software. That's dramatic. And there's not a lot of cloud providers in the world. Once you hit them where the bottleneck is, that's where you might impose real consequences for these companies. So it could be promising. It's just that it is an ex post measure, meaning that the harm will already be have been felt by the time that we get to imposing them. There are far too many companies in too many countries, and so it's not scalable to rely on this. We will only target the truly bad apples. And in any event, these companies might try to evade sanctions through mergers and acquisitions and rebranding to move to other countries or work with shell companies to avoid the effects. And in addition, so much of this depends on third parties reacting to the sanctions. So be it the investors reacting, or say the suppliers of the infrastructure tools like Amazon's reacting. And the question is whether or not they react. And so especially in the investor context, when Congress, the House ran an open hearing around spyware, one of the questions that the Congress people asked was, well, are investors really knowing how to deal with who are bad companies and who are good companies to decide how to invest? And the experts in the hearing all said they have no idea who they're investing in these contexts. So how do we educate the actors in this question? All right. And so we get to this thing that has been proposed now time and again. And I mentioned before that when I hosted this event with NSO Group, I talked to a few people. One of them was David Kay. And David wrote me this email saying that I would do a horrible thing for my future if I ran that event. David has taken a very strong view on NSO Group, but he's also taken a very strong view of commercial spyware as a whole. And he is really one of the key voices calling for a moratorium. There are others now across civil society. And I would argue to you that they're succeeding in some aspects of policy design. So on the one hand, the PEGA report from the European Parliament is embracing the moratorium language. And on the other side, the Biden administration's executive order from earlier this year is too, in a sense, a moratorium. It's just a limited moratorium. It's a moratorium on procurement by federal government of certain kinds of spyware tools. And I will get to that example later. When I started writing this, I said that moratoriums are wrong. That my core argument at the beginning was that they're not only impractical, that they are dangerous. I want to pedal back a little. I want to say that moratoriums as currently designed are just unsophisticated. The phraseology of moratorium is just not particularly smart. And it would be helpful to understand better what we mean when we say that word moratorium or attack ban. And there's a set of questions that we should be asking ourselves. So which technologies should be banned? Which kinds of spyware? Are we only limiting ourselves in the moratorium context to, quote, military grade spyware versus non-military grade or non-zero day? And how do we define military grade? These are all hard questions. Also, which companies? So I mentioned the Biden executive order. The Biden executive order is an utter mess. And so here's just some examples of how the Biden executive order defines which technologies cannot be procured by the federal government. It is only those that, quote, pose counterintelligence or security risks to the US federal government, based on, quote, credible information about whether the entity knew or should have known, and where appropriate measures, whether it took appropriate measures to prevent the following things: whether its tools were used against the US government or data about the US government was disclosed based on these tools, where its tools were sold to human rights abusing countries, where the company misused without authorization data from the spyware operation, and where its tools were used to collect information about a set of actors, namely human rights defenders and activists and academics. What I'm getting at with this definition is multifold. One is that this is very much American-centric. It's only interested in how do we prevent harm to America. It's not really interested in protecting human rights as a whole, even if in there is a restriction on companies that have spied on activists, where their tools have been used to spy on activists, academics, and political figures. But more importantly, the moratorium is limited only to foreign commercial spyware. That's the term that the executive order uses, foreign as opposed to American. And so it's not so much about protecting human rights as it is about protectionism. It's just about prohibiting a foreign commercial spyware industry while not setting any restrictions on American-based commercial spyware companies, which I think is interesting because here we're incentivizing really just operate from within the United States, and none of these restrictions will apply to you. But kind of defining what are the kind of companies you want to put a ban on procuring from, that's a question, as is the question of whether or not this is a temporary ban or a permanent ban. So I'll note to you that when the PEGA report talks about this is the European Parliament, it says a temporary ban until such time as we can have human rights protective regulations. And yet what the PEGA report doesn't do is define what human rights protective regulations are. In fact, it goes as far as to suggest that it cannot imagine any commercial spyware that is based on 0 days ever being proportionate under proportionality standards of European human rights law. So essentially they're calling for a permanent ban, even if they're not saying a permanent ban, because they cannot imagine a human rights protective regime. And finally, there's another aspect to the Biden executive order that I think is interesting. It says that it's only putting a moratorium on procurement for operational use, but it's not putting a moratorium on procurement for other uses, educational, development, R&D. So if you bought the tool to reverse engineer and figure out how you can design your own tool, that's an okay procurement. You just cannot buy it to use it for your own surveillance purposes, which again, if the point is to suffocate the market, it's not helping that you can still buy the tools just for particular purposes and not others. Okay, that gives you a sense of why the existing moratoriums that we know of, I don't think are sufficiently sophisticated. But I think the biggest problem with moratoriums is that moratoriums, especially about military grade, about 0 days, are rooted in a thinking that these tools are just bad, that these tools will have negative effects across the board. And I just manifestly disagree with that idea. And I think the context of it is the going dark debate. So I'm, again, assuming everyone, I know many of you know this stuff. And so I'm going to limit myself, but I'll just say, we rely on commercial spyware, that is to say, we rely on lawful hacking to respond to end-to-end encryption. And we understand that in an environment that is so rooted in end-to-end encryption, the only alternative to commercial spyware is to compel companies to hack their own devices. That was Apple v. FBI. If we kill the law enforcement's ability to rely on lawful hacking, the only result will be more Apple v. FBI cases, more backdoor discussion. It's crypto wars all over again. And I don't think that was a better solution. In fact, when Berkman Klein Center at Harvard wrote Don't Panic in 2016, following FBI Director Comey then saying, oh my God, we're going dark. They say don't panic precisely because you have lawful hacking at your disposal. So the entire argument that the Berkman Klein Center tried to propose is that lawful hacking is your solution to the encryption problem for investigations. You don't need to compel companies to backdoor their own systems. Except that if lawful hacking goes away, then we're back to compelled assistance. And I think the compelled assistance is worse than 0 days. And maybe that is if someone disagrees with my idea that compelled assistance is worse, I think that is a conversation worth having. So against this background, I want to propose a different way to think about commercial spyware. And so this is the second half of the paper. And what I say in the paper is that spyware companies are not selling you a technology. Spyware companies are selling you a vulnerability in an existing technology. In other words, they sell you vulnerabilities in securities. And we need to ask ourselves whether or not the sale of an insecurity is something that can be privatized. That is, can the decision-making around insecurity be subject to purely corporate decision-making? And so in this regard, I latch onto the literature around the privatization of inherently sovereign functions and the literature around privatization of inherently governmental functions. And I use the distinction between inherently sovereign functions and inherently governmental functions in the same way that the literature has. ISF refers to restrictions on privatization that exist in international law, whereas IGF, inherently governmental functions, relate to restrictions on privatization that exist in domestic law. And I'll try to argue to you the commercial spyware, that the privatization of zero-day hoarding specifically, and by the way, only that, is inherently governmental and sovereign. And so here's how I do that. The ICJ has recognized in the Nuclear Weapons Advisory opinion that there is a right of state survival. That right of state survival, I argue, entails a sovereign monopoly over zero-day hoarding. That is to say that the decision-making around whether or not we hoard a zero-day, whether or not we keep an insecurity in a software, cannot be left to private companies, because doing so chips away at the ability of the state to maintain its own survival. And I say that because so many of these 0 days have dramatic effect of critical infrastructure. And therefore, the ability of the country to protect its critical infrastructure in a cyber-intensive environment like we have today entails that the government, and only the government, be in the business of deciding which vulnerabilities are worth keeping, even at the expense of some insecurity, versus which vulnerabilities are required to be disclosed to companies to fix through patches because the insecurity would be too severe, even if it means that we're taken away from our ability to spy using that insecurity. In other words, the state's right to survival entails only the state engaging in that trade-off and not any other country. But it is very limited to these forms of zero-day vulnerability hoarding. Similarly, I'll just note that if you're unhappy with this argument, then to the very least, we should be very cautious. Even if there is no prohibition in international law on this form of privatization under my logic, at least this kind of thing, which is so closely related to state survival, should entail that we should be very cautious about privatization in this space and put a lot of restrictions on this privatization, even if we don't completely ban it. As for privatization of inherently governmental functions, here I focus on countries that have adopted a VAP process. Again, I'm assuming many of you know what a VAP is. I had a slide for that. I deleted it. But a VAP is merely a process in which countries adopt an internal interagency procedure for reviewing whether to hoard or not to hoard a particular vulnerability. So far, only 2 countries in the world have publicly admitted to having a VAP. That's the United States and the United Kingdom. But I'll just assure you from conversations, there are many other countries with VAP processes that are just not public. When a country adopts a VAP, what that country is saying is that that decision-making process around whether to hoard or not to hoard a vulnerability, it sees it as governmental. It sees it as one that requires interagency work that requires this very process of governmental decision-making. What you do by allowing a private market for zero-day hoarding is that you're allowing for the circumvention of the very VAP you proposed. Because instead of the government agencies coming together to decide whether to hoard or not to hoard a vulnerability, they can simply buy that vulnerability off the shelf without needing to go through the VAP that they created. And so I would at least argue that in countries that have adopted the VAP, the hoarding of vulnerabilities, of zero-day vulnerabilities becomes inherently governmental and therefore cannot be privatized. Now, what this entails isn't a moratorium on commercial spyware involving 0 days. Rather, it entails a moratorium on purely corporate discretion in designing zero-day vulnerability tools. So the idea is to develop a trusted vendor market for military-grade vulnerabilities, zero-day vulnerabilities, by engaging in deeper multi-stakeholder public-private partnerships. Essentially, how do we bring these companies into a public VAP process in lieu of them making the decision-making on their own? So this is where I depart from moratorium proposers. I'm not suggesting that because of what I just said, we need a ban on the privatization of zero-day that we need a ban on commercial spyware using 0 days. I'm saying that we need a ban on the privatization of the hoarding, but we can do it in other ways. It just requires some creativity. So within the limits of what I have left, let me offer you that creativity. So what I'm proposing is a lawful market for commercial spyware. And I will tell you that I've now had a lot of conversations with colleagues at the State Department who have been pushing for a code of conduct for the industry and have now gotten, after the second summit from democracy in March, over 25 countries on board in a year-long process to design some kind of code. They're suffering a lot of difficulties in getting a lot of consensus building around what that code would look like, but they're certainly welcoming menus, ideas on how to design these kinds of frameworks. And so what I propose here is one possible framework. It's a start of a conversation. It's by no means the end of it. And I cannot be the one that develops this. This needs to come from countries coming together and talking about these problems. But the idea is to create a market of trusted vendors that we can all believe that they have design tools that are safe by design, privacy by design protective, that they are accountable when their tools fault, that the countries who are part of the process only buy their tools from these trusted vendors and not from any other vendor. Now, just saying that is extremely controversial and pushes back against the calls of the civil society for a moratorium on this industry. So I have found myself stuck between a rock and a hard place when I propose these ideas, because on the one hand are these, and that's often where I am when I try to propose centric viewpoints on these issues. On the one hand, our civil society are saying to me, what are you doing? You're stepping outside of the party line. And on the other side, our government actors who are saying you can never imagine any idea of regulating such a secret practice of spying where countries will be willing to bind themselves in this way. So within the limit, I'll take only 2 more minutes and then I'll stop because I want to get to a conversation. The details are in the paper, but I'll just say the first question is, how do we define the very tools? I go with an expensive definition that is building on the Congress legislation. Essentially, it's any tool that does surveillance. And that means that any company that sells surveillance tools in any kind could join. I don't see any reason to restrict the kind of companies that are invited to take part in the process. The only thing that I differ from the language of the legislation that was passed in Congress is that language used the terms tools or sets of tools. I don't like that term, especially because we now are entering a world of spyware as a service, where you don't need to sell me a tool, you can sell me a service where you control the infrastructure. And so my definition extends beyond tools to services as well. But aside from that, I think that we need a robust definition to invite as many companies to be part of this framework. The second thing I do is that I build on an existing model. So I rely heavily on the ICOCA model. That's the International Code of Conduct for military and security companies that was generated in the 2010s in the wake of Blackwater and related incidents. I see a lot of parallels between spyware companies and these kinds of companies. In the paper, I discuss all the limits of ICOCA, the biggest of which is that ICOCA failed to create an enforcement mechanism within the model to ensure accountability. And yet that model is rooted in what I propose here, which is companies committing themselves to only procuring from trusted vendors and then setting a framework on how to review trusted vendors. So that's what the model proposes. The last thing I'll say, with this I end, is that what I imagine is an international agreement that has both countries and companies signing on to it. And so the idea is that both the countries take on certain commitments and the companies take on certain commitments. I also imagine civil society as observers with certain observer powers in the managing body. I discussed that in the paper. But the basic idea is that the companies commit to buying only from the trusted vendors, that they create national contact points to ensure grievance mechanisms for review, similar to the national contact points in the OECD context. And then a set of obligations on how you spy. That's the human rights tailored framework that I mentioned before on the spying countries. And then for the companies, they also are bound by certain human rights obligations that are now enforced on them by signing on to this agreement, by committing themselves to the agreement. So basically taking what the US State Department created with its guidance and making it binding, and then committing them to some internal review mechanism at the moment where they join, every year when they want to renew their activities. That's where transparency will come into play. Finally, saying that wherever there is a case of abuse, it can be reviewed within a quasi-judicial process within this framework. There's a lot here. I think that is the part that we probably might have a lot of questions and answers about. It's about the framework. So that's where I wanted to leave off. But I hope this was sufficiently provocative for having a great discussion.
Thank you so much, Asaf. It's been fascinating. And I'm sure that it will open up a significant discussion. Yuval wants to begin, please.
I want to ask. I don't necessarily want to begin. But thank you, Asaf. This is great, and I really enjoyed this. So three quick questions. One, NSO. So NSO has been really getting a lot of fire. But how much do you perceive NSO as an outlier in the field? I mean, there are a lot of the people of NSO that I spoke to at the time were very bitter about them being singled out from the market when at least they maintain. Again, I have no ability to check neither their claim nor their claims about their competitors, but they claim that they were actually behaving more responsibly than many of their competitors. And yet they were basically driven out of business because of some of the developments that you described. So the question is really whether dealing with NSO was a red herring, in order to sustain the practice. I mean, like we often see in human rights law, that governments, they single out one specific bad practice in order to continue engaging in many other bad practices. So this is the first point, which I want you maybe to comment on NSO and the state of the industry. Secondly, I think with NSO, a lot of the criticism was about who are they selling their products to. But then, and this is perhaps the part where I'm not sure that your framework would hold. If you even look at some of the alleged OECD clients of NSO, Mexico, Greece, Israel, they themselves engaged in more or less severe privacy infringements. So one wonders, and these countries allegedly operate within the standards that you refer to. Proportionality, human rights, courts. So I'm wondering whether this is simply an area where, like, espionage more broadly, violations are part of the game. I mean, there is really no space for effective or overly effective law application in this sphere. And finally, and that really goes to the viability of your program. I mean, I can see very well companies. I can see element 1 and element 3 happening. I'm not sure that element 2 can happen, that states would actually be sign on to these commitments. I mean, it may be if there is a cartel of spyware manufacturers who refuse to sell, but this is extremely unlikely. And even if they were to agree, following on the second point, I mean, the likelihood of effective enforcement here, like in many other areas relating to cyberspace and more broadly to espionage, enforcement is likely to be zero. So the question is whether you're hopeful. I mean, it's good that ideas are put on the table, and it's a bit cruel to to ask you to evaluate your own brainchild. But do you think that this is? I mean, how feasible do you think this project is, essentially?
These are all excellent questions that trigger a lot of important things to say. So let's start with the first one about. I heard that claim, that was one of the things that they said also in that meeting with the law professors from the U.S. And I worked for Privacy International. Privacy International was one of the entities working at the forefront of devising these, going all the way to 2006 when they started their surveillance industry index, the SII, where they monitored essentially companies doing this activity. They will tell you that there is a lot more companies who are doing bad things, more than just NSO Group, and they're doing all sorts of bad things that are not getting reported because attention span of governments is limited, and attention span of newspapers are limited. And so there is no question that we target, for all the reasons you said, we've targeted NSO Group. It became the company we love to hate. And in so doing, we've let a lot of other companies pass. And I think that what is necessary is an international standard. There's just no other way. This is why ad hoc responses are not efficient, because we have limited capacities and resources to engage in these ad hoc solutions, and limited attention from the kind of actors who might engage in the reputational harm activity to hold these companies to account. So in that sense, I share NSO Group's frustration that they were the one singled out. At the same time, I also acknowledge NSO Group did a lot of bad things, despite having the alleged frameworks in place. And I think now what has been reported means, and that gets us to the second question you asked, that even if you claim that you have a framework in place, be it your own corporate framework or the framework set by your licensing country, or the countries who have utilized the tools like Mexico, Greece, and Israel that you've listed, those frameworks are insufficient. They're insufficient to prevent abuse. Look at what happened in Mexico in the context of the disappearance of anti-corruption activists through the use of these technologies. And so what I would argue to you on that, and I think Israel is the perfect case study for that, is that the frameworks that we have in place are not tailored enough to the unique challenges of spyware. And Israel is just extreme to me. I think that the idea that we're still relying on the kind of rudimentary legislation that we have on wiretapping to try and suggest that is in any sense sufficient to address all the unique particular harms that spyware and hacking tools pose is ridiculous. And the reality, I think they know it. It's just I think no one is has any desire in wanting to design complex legislation. The only so when I worked for Privacy International in 2017, Yuval, you would know this because we went to the Human Rights Committee to report, was on the Italian bill at the time that tried to propose tailored hacking tool regulation. I think that is where we need to go. We need particularized legislation on the domestic level that is based on some specialized international human rights frameworks. I'm in some conversation with Fiona, the special rapporteur on counterterrorism, who has put out a report recently on spyware. She is looking to run an event later in the fall with the UN counterterrorism directorate within the Security Council to precisely start talking about how do we design human rights frameworks to address some of these problems. So the bottom line is, I don't think that the issue is that we cannot imagine regulation, is that I don't think that the frameworks we have are sufficient. That just saying proportionality and necessity and whatever are sufficient to address these problems. And then coming to the third question, I think is the most challenging. So let me start with what I imagine. I imagine starting with a club of like-minded countries coming together and signing an agreement and only working with a set of trusted vendors within the like-minded countries. Does that solve all the problems? No. Will that stop Russia and China from selling their own tools to third parties? No. Will that stop third countries from buying said tools from the black market? No. But it starts us in a conversation where and this is, by the way, what I think the State Department's biggest concern right now is, as conveyed to me in my meetings with them, is that they're really frustrated that the Biden administration was lambasted that for buying their own tools that they said are bad. So in the last year, there have been a lot of reporting of the Biden administration's FBI, I can't remember which other agencies, but a set of agencies buying, including tools from NSO Group. And so the ability for them to have a moral high ground to sit on, to say, here's a market that we help design through a framework that we are pioneering, that is more protective, that we can trust the companies within the framework, is what Congress is pushing them to do, is what they believe will help them have a better standpoint to talk about these issues vis-a-vis other countries within the international community. So I'm not imagining some solution that will now be necessarily be adopted by Israel, but I am imagining a set of very limited countries starting us on a path towards some kind of an international standard.
Thank you very much, Asaf. As a follow-up to this question, and the list is growing, so I'll keep it short. How can we justify creating a market and deciding which players can enjoy this market? Should only states buy the software? Should only companies? Can individuals buy the software, and etc.? Second, it seems that one of the hardest things to envision is to envision a situation where a spyware will not violate human rights by its nature, by its use, and etc. And here the question is the company the one who is violating human rights, or the user? Because in this regard, if you accept the assertion made by NSO, and it is a bit compelling that they're just the company, they create the technology, and it is another entity which is actually misusing it, then there is strong justification to do so. But you need to really convince that it is the user rather than the company. And in this regard, I think it will be hard to reach an international consensus, because in some states, people will have more faith in the government, and in other states, some people will have more faith in the private market. So, for example, in the US, they recently made a poll, and they discovered that people want a right to be forgotten, but they're not willing to give the control over it to the government. They want private companies to have it. And here in Israel, you see that the main focus of the government is against the police. It is against the authorities which enforce the law. And in this regard, it's not only the way we apply the law inside the state, it is also the ideological gaps between states like the US and China, Russia and Israel, and etc. And even within states which are like-minded, like Israel and the US, we can have different value-driven choices, which will make it hard to reach a consensus. So I think that your suggestion is really interesting, and we must pursue it practically and theoretically. But I think it's really hard to envision something which is so far away, and there needs to be like steps of envisioning the next step, then the next step, and the next step. Eventually, we will get to your final vision, but it is so wide, so significant, so far-reaching. So maybe you need to create some steps.
I'm completely with you. Let me just say a few things on, because you said a lot of really smart things there. So first of all, I only envision the clients being states and state actors and not private actors. And allegedly, that's what the companies have claimed they've done. But my framework says that you only can, any companies that joins is a company that commits to only selling to government actors. And for the same reasons around limiting the scope of diversification of who can use this tool, given the risks imposed in the tool. But then you asked whether spyware can ever be human rights protective or human rights compliant. And I'm not quick to brand spyware as a technology or as a solution being necessarily by design inherently a violation of human rights law. We need to say, so for example, I don't think any spyware tool could ever be used to manipulate data, delete data. I don't think that spyware, we might agree that spyware should never be used to collect real-time data, as only collect historical data. We can start setting frameworks, which, by the way, are not dramatically different than the kind of human rights frameworks we've been debating around wiretapping and around mass surveillance and for a while. And so it's, to me, the problem is that we haven't. Really, there's so limited discourse around how do we design a human rights compliant framework for spyware. But spyware as a tool is just the ability to hack a communication device. I think that that's what wiretapping is too. And the act of hacking, the act of hacking by design is not, to me, inherently against human rights, subject to us defining how the tool is to be utilized. And that, by the way, includes a lot of, and that's in the report by the special rapporteur. There's a lot of important work to be done on logging, on how the technology itself only collects evidence about how the technology could be misused by certain actors. And then ensuring that that evidence is available to the company to then hold those clients to account, and where necessary, even to present that as usable evidence in courts to hold them to account. And I think there is a lot of work to be done around that. I will say to you that a lot of what the spyware companies, for example, say on logging, on having the ability to monitor how your tool has been utilized on the ground, is that they say, if we impose this kind of, they don't challenge that they have the technological capacity to do that, but they do say that if we impose that kind of limitation, no one will buy our tools. And so that is a race to the bottom that can only be solved through an international standard, where if no country offers any other solution, then you have to buy the solution that comes with that monitoring. Which gets me to the international consensus stuff and how do we build a framework. I don't disagree with that at all. I was surprised to see the number of countries coming together, signing on that very preliminary commitment to further designing an international framework around commercial spyware that the US was able to achieve in March. I think that's impressive. And I think it tells that, and by the way, I think it's, as is always the case, a lot to do with the fact that these tools have now been utilized against leaders of states. I think that as we saw after the Snowden revelations, as we see now, whenever it hits them personally, all of a sudden it's a governmental issue that we need to deal with. And so at this moment in time, I think there's an opportunity to start small, and that's where we get to steps, and I agree with you. And the first step is to get some of these countries who are in some agreement about the need for framework to start talking about what that framework looks like. And this is modular, so pick up a thing from my proposal. It will already be a better world to live in than one in which we just constantly cite moratoriums left, right, and center that will get us nowhere.
Thank you very much, Asaf. Very interesting. As we have 4 questions ahead, maybe I will suggest we can collect 2 questions at a time. Will it be okay? Perfect. So Dafna and Dana, please.
Hi, Asaf. Thank you so much. definitely a very debated topic. I have a lot of thoughts about it. I want to look at it like from a broader perspective. Basically, when we're saying let's create a legal framework, that means let's legitimize that tool. Now, I wonder, I mean, if we look at the context, we're in an age where there's like huge technological, scientific development. We develop measures to influence brain activity and neural aspects, etc. So I wonder if even if we're going to create a very good legal framework and only states can use it and only certain states and et cetera, if it might be a bit of a dangerous precedent when we're looking what's ahead of us.
Dana?
Asaf, good to see you. It's been a while. It was really interesting. I have two questions. One is, what are your thoughts about maybe personal sanctions for employees? As I think at NSO, my impression was they had a hard time rehiring later, as the people didn't want to identify themselves with so because we can't really trust the companies and we can't really trust the state, so maybe this part, and maybe it's more of a comment than a question, but I always wonder, because there would always be those companies who wouldn't play along. So everybody talks about how to regulate Facebook and Google, but no one talks about Telegram because they're just unregulated. So I wonder if regulating those who would play along maybe cause more harm than benefits, as there would always be those, the race to the bottom would always be there.
Great. Okay, so I'll take both of these questions in turn. So starting with Daphna's question, and by the way, I want to say again that this is all the people alive in the world all coming together in one Zoom room. So I'm very happy. So Daphna says, are we not going to be legitimizing a tool that should not be legitimizing? And so the answer I'll say is that I want to understand what the alternative is to this proposal. And right now, the only alternative I'm hearing, the only meaningful alternative I'm hearing is a ban on the market. And a ban on the market sounds very human rights protective. And that's why, by the way, at Privacy International, when I worked there, they often called me the mole in the room, because I would often come on with these centric proposals that are influenced in part by the fact that I worked for the Israeli intelligence for a while, and I've seen the other side of things. And they would often ask me, are you here because you want to work with us, or are you here because you want to put sticks in our things? And I said, no, I really believe that if you care about the audience that you're trying to propose all your proposals to, you want to speak in their language. You don't want them to shut you out by just saying a thing that sounds very purist, but has no practical, it's not a starting point for a lot of these intelligence agencies. That was an ongoing debate between us. Ultimately, I landed on the idea that if Privacy International as an organization will not speak the party line, will not voice the purist form, who will? So they play their role. That's their role in the discourse, is to speak a purist voice, so that in the tensions and dynamics of the conversation, something in the middle will take some of their concerns into account. But I think that a moratorium is a non-starter. And it's a non-starter from a human rights perspective, because I think that if we did impose a moratorium, not only is it impractical for the reasons that Dana started to say about the people who will not play ball and the people who will play ball, and so the market will still be there just in other forms and just by particular actors, because essentially if Western countries will not sell these technologies because they will not have it, Russia and China will sell it, and they will take the data and will use it for their own purposes. Is that a really better world to live in? That's the practical point. But there's also just a human rights point here. If we restricted law enforcement in Germany for relying on lawful hacking, I think the solution is for Germany to compel companies to backdoor their devices. And I sit very comfortably on the argument that that is a horrible world to live in. that if we now ask Google and Apple and Facebook to design software that are by design have faults to comply with compelled assistant requests, that's not a better world to live in. And I say this because maybe we say, then we need to constrain law enforcement's hands altogether. Law enforcement should not investigate serious crime using any tool that goes against end-to-end encryption. I just don't think we can live in that world if we care about child pornography, and we can, this is where, and this is the classic NSO argumentation. Yeah, go ahead, Daphne. I see you have a response.
No, I want to say that, I mean, I partly agree with you, but you can say it about a lot of things. I mean, when the drug conventions were created, there were drugs and states selling it, and still they say, no, this is wrong, although some states still have a dark, like, drug market or whatever you call it. And you can say it about chemical weapons and a lot of other things. So,
but you know what? It's interesting you're going there, because obviously you're given a lot of dual use examples, which spyware is a dual use example. The reality is that in all the examples you cited, it's not that we've take drugs. It's not we've prevented the restricted.
We banned the sale of it,
except for medical exceptions when necessary, in particular circumstances, in particular ways. And I'm no expert on drugs or chemical weapons to get into the analogy there. I'll just stick with investigations where I know it. I really don't see how you can conduct today an investigation on cybercrime without having some hacking tools available to you to engage in that investigation. So I'll just, because I know we're running out of time, I'll just end with Donna's point. On the hiring, I think that's a really interesting point. I think you're right that NSO groups struggled to hire, and people, in particular, people who identified themselves as liberals, were having a hard time coming to terms with having NSO group on their CV. And what that means to me is a need to reconceptualize corporate governance. And we saw that, by the way, also in the Google boycotts of an agreement between Google and DARPA for the creation of particular AI solutions, where Google employees just stepped aside and said, we're not going to work until you cut that deal out. Ultimately, it was not effective. It was effective in the moment because Google backed away from the deal. But 2 years later, the person who led that marches left Google. There was less of a company employee base to push back, and Google signed a new deal with the Department of Defense. What it shows to me is the need to institutionalize, say, membership of employees on the board, a representative of the employees on the board, or having some power for the employees on policy design around how we engage in some of these activities. This is all corporate governance solutions. I'm not a corporate law person, but I certainly think that that is where some of that conversation can go. And certainly as we standardize the framework, one can imagine that being a requirement that you impose on these companies. And as for the countries that will not play ball versus the countries that will play ball, you're right. Again, my only thinking there is, if we go back to Tal's question, if only countries buy this tool, then there's certain countries with a lot of money and a lot of purchasing power, and certain countries with less money and less purchasing power. And so that creates a leveraging for the powerful states, which tend to be the ones within the club, to then impose, if we don't buy your tool from you, then you might not have a significant enough business that merits continuing to exist. And so it might be enough at some point, we might cross over where there's enough countries with enough procurement power within the club to compel more companies to join the club that way. But that's an empirical question that I have no evidence to support yet.
Thank you very much, Asaf. It's really interesting, the employees point, and at times it's actually the cautiousness comes from the directors. At Microsoft, I think it's Brad Smith more than the workers. Cautious, so it's interesting. We have questions from Cedric and Deb. And Asaf, we have time to hear you.
Oh, I don't know. Where do we finish? Sorry, I just didn't know.
We can continue for, let's say, 20 more minutes if you have the time.
I'm here.
You're still under the script. So Cedric, Deb, and then Thibaut is also joining.
Okay, hi. Hi, Asaf. We never met in person, but I think I know you a little bit through your writings. I think we share a lot of the same interests professionally. So nice to meet you. Also, I work for the government, and I don't want to walk on eggshells, so I'll take off my government hat for a moment. And also, I can say I wasn't present the first half hour, so maybe you said some amazing things or some things I might disagree with, and that's fine. So it's kind of a general comment and like food for thought. Sorry. Without going into the substance of the issue, first of all, it was really interesting, so thank you. So without going to the substance, I have to say I find your proposal really interesting because it reminds me of a similar issue that was really at the forefront of discussions a few years ago with respect to active defense, what some people called hackbacks. So there was this healthy debate regarding the possibility of authorizing companies to take self-help measures to defend themselves against cyber attacks. But because it raises questions about international relations and international law, other things. So one of the proposals that had been put forward at the time was accrediting large, experienced cybersecurity companies to take limited active defense measures under, specific conditions and subject to government oversight. And kind of like as a centrist solution to the issue, we don't want to empower companies to take the law completely into their own hands, but we also don't want to leave them completely helpless either. So I'm aware it's not exactly the same thing, but I see a similarity in the overall concept. It's kind of like saying we need a practical solution. We're not going to satisfy the maximalists on either side, so let's kind of find a middle ground. And also, we see kind of a similar approach with content moderation under the DSA in the EU, where we have this concept of trusted flaggers. So it's this general idea of like the government accrediting a company that works under certain conditions and that's accountable, and it kind of creates trust. So it's like regulation for trust. And I wonder if it's a model that works, that can be replicated also in different areas of governance. So, we might think in the future developing quantum computing and that kind of thing. So anyway, these just different ideas that came to mind, and I'm happy to hear your thoughts on this. Do you think it's similar? Is there enough of a similarity to actually create like a general overarching concept?
Are we still taking two?
Yeah, I think if Deb is willing to share the
Well, Tal's really not interested in hearing the second question. So thank you very, very much, Asaf, for a really interesting talk. And you had asked us at the beginning to sort of reinforce you as you wait by your letterbox. So the AJIL will no doubt ask you not only to publish what you've written, but to expand upon it. And so I think it's a really, really, really good job in terms of the analysis. Too often, the academic articles sort of, we're all guilty of this, or I am, just sort of flit off into the distance. So I think it's a real positive that you have the model that you propose. And I have lots of questions. I'm going to restrict myself, I think, to two. So first of all, it's a comment and question. I'd really like to hear more about what you think about the licensing process. So Israel's API and the Ministry of Defense here has been really in the public eye. So for spyware, the vulnerability is the business model. That's what's getting licensed. So my query, since I'm not in those closed rooms, and you perhaps are, is where vet processes are in place. And by the way, I think the Netherlands also has one, so that might be something to check. When they're in place, to what extent do the licensing processes, where actually the company with the intent to market a vulnerability or to base their marketing on a vulnerability, to what extent does that process come into the licensing process? And if it doesn't, why doesn't it? Obviously, it would have to be protected since it's a business model and et cetera, but shouldn't that be part of the licensing process when it can be? Or maybe that's part of the machine that you're building to have more eyes on this, on that part. And the second part of that, I'm not even saying it's like question is, Tal, when you said that we needed to look at the end user as well as the company, I also wonder whether we don't need to look at the licensing body in terms of its role in potential human rights violations, and whether that not that's sort of the originator of the entire problem. So what are the constraints beyond international human rights law on states? What are the constraints that we want to impose upon licensing bodies? So that was point one. And point two that it just came to me as you were speaking, and it's because you're so knowledgeable in the field of how insurance is a market driver. I'd be really interested to hear your thoughts on how I see two people falling on the floor laughing, but Asaf, what did NSO and they're like, what do their insurers require in terms of transparency and being understanding better the business model, and how can we better leverage the insurers as overseers?
Wow, as the conversation gets on, as the questions gets harder. I love that. So I'll start with Cedric. First of all, likewise, we never met in person, but I know you and your work, and I'm glad you're here, and I'm glad we get a chance to interact. I think you're spot on the comparison. I will note to you that one of the critiques I got from Angel is to flag more parallel literatures, and I think that exactly that kind of literature should be flagged more clearly in the final version of the piece. That is to say that we see that a lot in the need in cyberspace to scale up, and it's a scalability problem that is generating an under enforcement problem in cyberspace, and it is against that backdrop that we have come to varied forms of privateering to respond to particular challenges in cyberspace. I think that there's a lot of that literature. A lot of the challenges in that literature too are also flagged here. One example of that for me that I've written about is botnet takedowns by Microsoft. I think that that is an example for me where the privatization isn't going very well, because it generates a monopoly by Microsoft over that entire business of botnet takedowns. Microsoft claimed that through its actions in courts in this somewhat constrained model, but not, as I would argue, sufficiently constrained, it has helped to take down these botnets and respond to the threat that they pose to the American economy. But Microsoft is the sole actor that is engaging meaningfully in these botnet takedowns. And I would argue to you that they're doing that in a way that is abusing the particular remedial tools that they use, which are injunctive relief in courts. All to say that when we invite private actors to do the work of replacing the state in some aspect, we need to be very, very cautious. And in particular, we need to be cautious not just about what the diplomatic effects, the international relations effect of that could be in deteriorating and destabilizing international affairs, but we also want to be mindful about the market dynamics that it helps produce. And so I'm mindful of that, and that's why I think the need to talk about privatization in the spyware context is something that I don't see a lot of literature on. And by the way, I will say to you that more broadly, because I write about espionage all the time, I also don't think we've dealt enough with the privatization of espionage as a concept sufficiently, and understanding, and in America in particular, here in the United States, we've privatized every aspect of the intelligence cycle from top to bottom. And there's a lot of harms that have been produced by that contracting, not least of which is the release of leaked documents by contractors, as we just saw in the last few months. And so I do think that there's both great parallels. I will note to you that I would not go as far as to compare to constant flaggers in the content moderation space, just generally about the move from corporate actors to individual actors doing the work of the monitoring. This is where it flags some of, is it Tamar Megiddo's work that is now looking at privatizing to individuals to monitoring. So that invites this kind of environment where individuals are surveilling their neighbors types. Her article is great. That's all I'm going to say about that. The bottom line is that what I'm proposing is exactly what you said in the first example, in the active defense and hexback example, of accrediting large experienced companies to do this. But then too, we want to be more careful about defining these companies in a way that doesn't create problems on the markets, challenges on access to particular competition and issues like that. That's what I'm getting at. Okay, I hope that was helpful. As for Deb's, great questions. So first on the licensing point, part of the problem is that there's no uniform licensing framework. Even those countries that comply with the Wassenaar arrangement are not obligated to employ the same exact license, the model of licensing and the way the licensing body works. And it's on a lot of things, including on the proprietary data aspects, on what you can compel or not compel the company to release to you, as well as it is on the form of license, the authorizations to sell regime. Are you authorizing them to sell this particular product to this particular client in that particular country? Or is it a more broader license to sell this technology to X countries? The design of that is not uniform at all, meaning that thereby there is more open checks and more, as opposed to more constrained and contained licensing arrangements. And so what I propose is definitely one that the countries that commit themselves to the regime commit themselves to a more stricter licensing arrangement where all the countries have some uniformity on the formology, on the particular reviews, on how they check and how the companies answer them, including where there is an international framework where the companies have to release data. And there is ways to do it. You don't have to release the crown jewels of the company to still share some aggregate data about the types of clients who've used your technologies, the way they've used it, the kind of contractual language you use in your contracts, and so on and so forth. Insurance is super interesting. I'll say a few things on insurance. One is a lot of this will be done through access lines. So it will not be done through the traditional commercial insurance market. These are such tailored needs for some of these companies, that at least for some of them, you might work with unregulated insurers. And the ability to hold to trust the insurer to do a good job in regulating this is questionable. For some of these companies, the solution has been to rely on self-insurance. Why rely on an insurance company if I can just put some money aside every month for rainy day? And a third thing to say, and this is something we've seen from the insurance regulation of police activities, because a lot of police departments buy insurance too, is that insurance have no idea what they're doing in the national security space. And so our ability to trust the insurer, to understand what questions to ask, to build insurance policy that is tailored to the particular threats is very hard. What is certain is that when there is a sanctions, now it's really hard to buy insurance. And so at the end effect, there is an end effect, similar to now it's hard to get employees to work with me. Now it's hard to get cloud service providers to work with me. That's across the board. But at the ex ante phase, before there is a blacklisting, trusting an insurance company to know what questions to ask of a spyware company that wants to buy liability insurance, good luck.
Thank you very much. Deb, you want to respond quickly or?
Yes. Thank you, Tal. Yeah, you read my mind. Just really, really quickly. Yes, and yes. However, we're seeing a slow turtle-paced crawl in the cyberspace, or insurers. You're, of course, absolutely right. It's almost impossible to buy cyber insurance today, but the questionnaires that the insurers are sending when they do offer a cyber insurance policy are way ahead of what they were even 2 or 3 years ago.
I cannot agree more. You're absolutely right. It's just that what we're talking about here isn't because now
they're not even there. They're not even in the ballpark.
Cyber insurance is a mundane product, and at this point, every small to medium business is buying it. How many companies are buying a tailored spyware?
Right. Thank you.
I think that the questionnaires can serve as a way to find new vulnerabilities in the client. Maybe that's the point. Thibault, you want to raise the last questions, last comment?
Yeah, thanks. Yeah, indeed. Thank you, Dad. Thank you, Asaf. Nice to see you. Nice to see you all, by the way. I'm gonna pick up on past questions, actually, especially Yuval's one. I mean, at some point you refer to the European Union, and indeed, we all know that the European Parliament investigated the use of Pegasus and the like. And as you well said, it had concerns regarding Greece and also Poland and Hungary. I just wanted to know your feeling about EU regulation. Well, if you had the opportunity to work on it, because I had the feeling that there was a lot about exportation and licenses were referred to at some point. But very little about importation. So what did you think about it? What was your feeling about it? Thanks, Asaf.
First of all, congratulations on your new book. I just want to say I have it, and not only I have it, I use it. I like there's notes in it just to show you that I've read it carefully. Congratulations.
Happy to know it's useful.
It is. No, it's really helpful.
We have a book for every participant in the.
I'll just pull it up.
Okay.
So right now, what we saw is a process that has culminated within the PEGA committee. That is a parliamentary process, and in fact, a good chunk of the PEGA report complains about lack of support from the Commission and lack of support from member states. And so a lot of what they're indicating through that in their report is that even what they're proposing, some of which includes regulation, is unlikely to be picked up in the immediate future. And so I'm just not particular. I think the report is very dense, very thorough, in particular on the part of the investigations they've done in some of these Eastern European countries that have relied on spyware tools. But I think that ultimately it will boil down to these G2G based processes. I don't think that we will see Europe in the same way that Europe has done for other areas of cyber and privacy issues, being at the forefront of designing a new framework for spyware. I do think that, and I'm solely basing myself on what I'm hearing from my conversations from here within the United States, which by design might be biased. But I am hearing that on this particular issue, the leadership currently is in the United States, and that all these European countries are working with the United States in coming up with a solution, but they will not take the lead on that in and of themselves. And it's rooted partially also in the understanding that a lot of the businesses currently are operating in Europe, and so there's a careful walk to walk for these countries, especially the ones where they have an active spyware market, on how to regulate without impacting their own activities. Europe has been routinely criticized for not having sufficient cyber capacities and for relying on these kinds of regulations that have resulted in curtailing and stifling competition and creativity and technological evolution in the space of, and that's a common critique on regulation. And so, especially in this space, I think that they will be a second joiner, but they will not be the first joiner.
Thanks.
Thank you very much, Asaf. As always, this presentation and the research which underlined it, very thorough, very comprehensive. It seems like you have taken the work of all of us and and found a way to reorganize it and to re-envision a field. And I always say it whenever I can. You are a true lover of, you're a true philosopher. You love wisdom, but you love people no less. And your ability to combine between your vigilance in the research and between the brilliant writing and between being such a kind person, full of empathy, and being able to recognize other people's work and reading everyone's work and finding the time to do it, it's auspicious, but it's also heartwarming. And it's always a delight to be part of a discussion with you. And we really cherish you, and we really miss you here in Israel. So,
first of all, the compliments will definitely go to my head. So done in moderation. No, but I also say I'm coming to Israel it's my first visit in 2 years. But I'm coming to Israel this spring. I'll be there March, April, and I was planning on reaching out when that happened. And
So we
look-
will have a physical session,
yeah.
screen-time session. Thank you very much, Asaf. We could not have hoped for a better ending for the academic year. Thank you very much, everyone, for bearing with us, for taking this academic stroll during this year. We will soon publish the newsletter, which will summarize our year. And I wish you a wonderful summer, full of relaxation time, but also good work. Yuval, you want to?
Thank you, Tal, for all of your hard work in keeping the flame alive.
Thank you. Okay.
Thank you, everyone.
We'll be in touch.
Everyone.
Bye, Toda.
See you. Bye bye.